they can actually use these types of fora. So it's really, really good and fantastic that we're finally having this conversation so that this sort of misunderstanding can be cleared up. So the CAS, the player chambers, the player status committees, the PSCs, the national chambers, and then obviously the relevant ones for tennis, golf, cricket, etc. They all have their own type of chambers where they handle disputes. But for commercial disputes, it could be a breach of an agreement, it could be a sponsorship agreement, it could be licensing, anything of that nature. You really, really want to be taking those disputes to the real commercial arbitral institutions that have the competence, that have the arbitrators and mediators on the ground to handle. I mean, I can give you a great example. Prof. Tunde Fagbonlu, who is at Aluko Anoyebode, he was the sole arbitrator for a dispute involving, I think it was construction, relating to the All Africa Games. Okay, a lot of people don't know that. So we really need to raise the awareness that sporting disputes of a commercial nature are handled really by the commercial arbitration bodies. And one thing I can tell you that is a really good trend we're beginning to see. We're actually beginning to see bodies, for instance, in Hong Kong, where I'm empaneled. I actually educated. I did a session over there and I explained this dichotomy of sporting and commercial sporting disputes. And they now have their own sporting dispute pilot scheme, which actually combines both types of disputes. So for the first time, we're seeing a sporting dispute body that will be fully empaneled and empowered to handle both sporting and commercial sporting disputes, which is a very welcome change. So that hybrid nature is not something we're used to seeing. So I do think that as more bodies get more awareness about the need to bring the commercial disputes closer, hopefully we'll begin to see more even sporting regulatory bodies begin to take on sporting disputes of a commercial nature. But until that time comes, sporting disputes tend to be serviced by the regulatory bodies, the federations, and then the CAS. And then you now have the commercial arbitration bodies, the private bodies handling the disputes of a commercial nature. So I hope I've kind of made that point clear about that kind of distinction between the two.
Yeah, thank you so much, Beverly, for that. That was really insightful. I mean, you actually clarified, right? You actually clarified the difference. So not all disputes, right, are expected to go to CAS or
No.
dispute that's going to be. So there are several other firms that we can explore. And you also stated the different type of disputes. Yes, you said we have sporting disputes, we have disputes of a commercial nature. So not all disputes are popularly heard institution. You also stated the issue of awareness and contract drafting. In fact, I think that the most important thing, the first point of call, it's during the contract drafting stage.
Yes.
That's when most of these issues, you can never get it wrong when drafting. You can never get when drafting. Done as clause, everything is stated clearly. Based on that, I'm going to come back to you. But for now, let's move on to Pauline. Pauline, I'd like to get your perspective on this. So, talking about the whole dispute resolution and the whole issue relating to contracts and how it's negotiated. Right, Pauline, I am aware that you have experience in advising football clubs and sports stakeholders across the different jurisdictions and sports federation rules often introduce something that's called, they often introduce sophisticated standard contracts and mandatory arbitration clauses drafted. Now, from the standpoint of an African sports stakeholder, right, these clauses from the position of strength, most of these, can you hear me, Paula?
Yes, please, I'm
Can
listening.
you confirm you can hear me?
I can hear you.
Okay, thank you. Right. So from the position of strength, how do you think a smaller club can actually negotiate such standard contracts or the whole compulsory mandatory arbitration that most of these bodies actually tell them to sign? How can they actually do that? Because at times you see most persons thinking that they are so from your policy that yes, Pauline, over
Yes,
to you, please.
yes, please. So I just want to confirm you can hear me.
Yes, I can hear you. We can
Okay,
hear
thank you
you.
very much for this question. And of course, before I respond to the question, I'd like to appreciate the invitation to celebrate the IP Intellectual Property, since today is Intellectual Property Day. And just to now quickly respond to your question. Firstly, is that a standard contract doesn't mean that it is not negotiable, or a standard clause doesn't mean that it is not negotiable. Can you hear me?
Yes, I can hear you.
Okay, so a standard contract or standard clause doesn't mean that it is not negotiable. Okay, it is very negotiable, and that means when we're negotiating these contracts or these very clauses, we have to be very tactful, especially if the clubs are not like these very big clubs which have names. So ideally, the first thing to take note of is that these contracts, in as much as they're found to be standard, they don't equate to the idea of it's non-negotiable. Secondly, when we talk about arbitration, is that arbitration is a creature of mutual understanding, which is a result of consent. Okay, so if you agree to have an arbitration clause in a contract, there has to be a mutual understanding, which is a result of consent. Two parties must agree that they'll be able to resolve their conflicts or their disputes by arbitration. So it is not by force. And that is something that I'll be discussing later on when I finish this strategy. So the best strategies for small clubs or even very big clubs, the first thing is that there is need to localize arbitration. Okay, localize the arbitration forum. The reason why localizing the arbitration forum is very important is that clubs do not have, or any other parties do not have to face issues of taking their disputes to other jurisdictions, because fees matter. And the first thing, fees matter, the fees that you pay for arbitration, of course, the transport, basically the entire arbitration process. So the first strategy in regard to this would be to localize the arbitration forum. And of course, there is something that is called cost capping. And this is something that some parties don't really take very seriously. And it's not just clubs, but all parties. Fees capping is basically where we look at the more wealthy party actually covers arbitration costs. This may not be a very easy thing to get to in terms of having a consensus between the parties. It may not be easy to get to, but it is something that has to be put in contention. At least if it is not that the wealthy party wants to bear all the costs, at least there has to be a share that is reasonable to both parties. So instead of saying, okay, each party should bear their own bear their own costs. Okay, so that is something that is very important to do. But even before we discuss this whole idea of localizing the arbitration forum or even looking at cost capping, it's important that we look at the judicial process, okay? So normally in sports, before we even get to arbitration, for example, if you file a case at the CAS or at a tribunal, a dispute resolution tribunal, that they will offer you mediation. This is basically if your mediation is not successful, we can actually go to arbitration. And mediation is always more affordable than arbitration. And for example, at FIFA, it is free of charge. So if parties can actually agree to having mediation and then move on to arbitration, that would be the first great tactic they can use to actually impose some level of power on the other party. The reason this is very important, it shows a consistency in the judicial system in terms of resolving conflicts. But again, it also shows that arbitration is not a must. So you must not agree to arbitration. And that is why I said that arbitration is not something that is imposed, but rather something that is a creature of consent from two parties. So there is a mutual understanding. And that is why I'm saying that because it's not a must, you can start from mediation and then you move on to arbitration and you have the issue resolved. And then, of course, when you have established this and you move on to the arbitration clauses where you localize the arbitration and where you cost cap, you can also just have limitations, okay? Limitations on the scope. It's not that every dispute should be taken for arbitration. Because if every dispute should be taken for arbitration, imagine if more than 2 disputes come up and it is the smaller club that is being disadvantaged. That will not be a great thing for the club or a party that is, for example, doesn't have a lot of power, especially when we're talking about a South African context. So having a limitation on the scope is very, very important. So why you can say, okay, should there be any issues of, say, intellectual property rights, if there is an intellectual property dispute, we will actually have this sorted out with through arbitration. And if you actually say we will actually go according to first approach it with mediation, it is even a better way. And the reason why this is very important is basically to give a certain level of power to the smaller parties. Because if you do not negotiate all these kinds of ideas or aspects before you get to a contract signing level, that means there's going to be issues that are arising when it is time to resolve these disputes. That means the small parties cannot even go to have these issues resolved because, for example, they may not have the finances. Beyond that is that they may not actually even have they may not be able to go, for example, to the jurisdiction of arbitration that you've chosen. So that is very, very, very important. But of course, now, when we look at all the fee strategies that I have mentioned, once an arbitration clause has been put in a contract and clubs have put these things in the contract, the next thing is we have to look at the issue of public policy and if courts are going to accept it and everything. And the first thing to notice is that courts do recognize arbitration, and that means they do enforce arbitration awards. However, the issue of public policy comes into play, and this is why we have to discuss the strategies before we get to the arbitration itself. Because, for example, the courts will not accept to enforce an arbitration award where a certain party was coerced into the contract. That is to say, where the smaller party doesn't seem to have consented to the arbitration clause. That means they were forced to actually sign. And that is why and that is something that usually happens sometimes, especially when we look at clubs in Africa that are signing contracts, big contracts with big companies. They're always told, oh, this is a standard thing, so they think that they cannot actually negotiate, and then they don't get to put all these things I've spoken about in place. But the first thing is that there is scrutiny in terms of how the arbitration clause came into the contract. And of course, when the court cannot enforce that, but also where the process was not actually fair. That is to say, where the other club did not have the opportunity to actually present their case fairly for them to get a fair clause. So that would be a very big issue when it comes to enforcement of this arbitration decisions. And that is where the public policy issue comes in, the fairness part of it. And then, of course, consent. You know, some people, like I've already said, there is coerced consent, and then access to justice. Was it a fair way to do it? Yeah, so these are some of the things that come into play when we look at arbitration that is brought into play. For example, if there is an IP dispute and then it is solved in Switzerland, there has to be an analysis of, okay, before we go to arbitration, how did the parties sign a contract? Were they coerced into giving consent? When if they weren't coerced when it came to arbitrating the matter, do they have a chance to have a fair hearing? And of course, when all those things are answered in the affirmative, that means the decision can be enforced. I hope I've answered your question. Thank you very much.
Yeah. Thank you so much for that was very, very, very insightful. You mentioned that standard contract are negotiable. Standard contract are negotiable. And then you talk about the whole issue of arbitration, right? And then you clearly stated that you don't have to agree to arbitration. You don't have to agree to arbitrate. Although what we actually see in practice is that we actually see situations where from the contract or most of the smaller clubs are expected to sign to sign agreements that states that you must submit to arbitration. That's actually what we see. You must submit to arbitration. So are you saying that because you don't have to agree to arbitrate, are you trying to say that the club should not participate? Let's say using football as example, the club should not participate in a league, or the club should not also undertake a particular sports event because they are not going to submit to the arbitration, because the law makes it clear that you must you don't there's no recourse to court. If you're going to come under the system, you must arbitrate. So are you trying to say that it's not that at that point you can actually decide whether or not to accept, whether or not to sign up
I
as
could come in
a
here.
club
I could come in.
or as a team?
I could
Or
I
you
could come in here
can
if that's okay.
just we are liberty, because that's what I hear you say, that we are liberty to make that choice at that stage.
I could come in here. I don't
Can
think
you
that's what
can you hear
Pauline is.
me, Pauline?
I don't think that's what Pauline
I
is
mean, you
saying.
can if you have a different view
Yes, please, I can hear you,
and let
Sonia, but I
me
think you
know
have a problem
on
with
that.
your.
Or Beverly,
I was
I'm
going to
so
just
sorry if
chip
I
in and say
mispronounce your name again. Can you?
Beverly. I was going to say that's not
Okay,
what Pauline was saying. Pauline was talking about
okay,
arbitration being a party-driven process. But I do
okay.
see the point you're also trying to make, that given the very regulated nature of sport, you see, the thing is we need to be careful because we are veering into the sporting type of disputes. And I know we are here today to talk about commercial sports disputes. But what Pauline was saying is that arbitration is party driven. But yes, unfortunately, within the sporting, at least if you're talking about sporting disputes of a regulatory nature, there's little you can do actually to get out of arbitrating, because most of the time it's going to be clearly stated in your contract. You can't go to court to seek recourse for something concerning eligibility or say breach of league rules or misapplication of rules or whatever. You have no choice but to use the uh, standard process, which is you go to your national chamber. If you don't like the result of the national chamber, you go to Switzerland. But when we are talking about private contracts, sporting, commercial sporting contracts, which is what I think we need to discuss here in line with WIPO, at that point, yes, it's party driven. The parties themselves will select the forum. So let's say Nigeria Federation has an agreement to manufacture their jerseys somewhere. they will sign a private contract with a manufacturer in China, Kafanchan, Enugu, wherever it is. That is a private contract. They will now decide what the forum will be, how they will submit, which is where Pauline talked about mediation also becoming a very popular way of handling disputes in sports. So mediation too is actually well equipped to handle sporting disputes of a commercial nature, because like she said, it's more informal, it's cheaper, it doesn't have all those rigors and formalities that you would see in arbitration. So actually, parties can really drive the process well if the mediator is very good and competent. So I do commercial sporting disputes, IP, yeah, mostly IP disputes, I would say infringement, outside a regulatory dispute environment. So it's just, I don't want us to end up going down the sporting, because it's very technical. If we now go down, we're here to talk about commercial sporting disputes, which are most of the time not going to be handled by your regulatory bodies and by the CAS. Is going to be handled by the private commercial arbitral bodies. But one thing I will say, just to support what Pauline talked about, is you do have sometimes lawyers, counsel who try to frustrate arbitration proceedings. And in Nigeria, it's quite common where you find people will submit to the jurisdiction of an arbitral body, and then they'll run to court and try and get the award set aside. And this is causing a lot of problems. Ambush tactics are just, we all know this. I think general commercial arbitrators know that this is a major problem, but the courts now are beginning to learn, the judicial officers, the judges, they are beginning to see that if we continue to set aside awards outside the narrow grounds, we will make our jurisdiction very unreliable, very unsafe, and we will end up losing out because more people will prefer to use foreign seats. So I think one of the things is, how do we also make Nigeria or Africa as a whole a more the first choice as a seat? We often see seats located abroad. I gave the example of the massive billion-dollar media dispute that happened between CAF. CAF, to my mind, is a major regulatory body. And I ask myself, how come a major regulatory body would allow their dispute, the seat of their dispute, be taken outside the African continent? To my mind, I would say that we should have our seats in Africa, because we have competent arbitral institutions that can handle some disputes of a commercial nature. So again, I think it's an awareness thing. We need to get the awareness up. We need to get more sporting arbitrators that have commercial experience, that understand IP, that understand the commercial gamuts. We're talking construction. We're talking so many dimensions of commercial activity that you can also find within sports. So we need more people that understand this, and we need arbitral institutions to also begin to factor sports in their categories. We still have too few institutions that are African that are supporting sports disputes, which is why they're going out of Africa. Very few arbitral institutions support sports disputes. Okay.
Yes. Thank you so much. I didn't have so much to say. Thank you. Thank you so much for that. Please, thank you for the clarification. On that. We really appreciate that. Okay, so because of time, we are running with time. Yes, Mr. Femisi, please, over to you right now. So I would like you to zoom into drafting craft. So I know that as you're an experienced international sport lawyer, sees business right now, we're still there at the moment. So I would like you to just zoom into this IP clauses usually end up carrying, that's in the contract itself now. IP clauses usually end up carrying the greatest weight when it comes to when dispute arises. But then it's frequently treated as an afterthought. Right. So what drafting essential or features should a well IP contract, a well sports contract, what drafting features should it contain, right, to sports contract, and what common mistakes do we usually make when in relation to that? Can we get your thoughts on that, Mr. Femisi?
All right, thanks very much, Miss Sonia.
I think it's
Yes, I can hear you. I'm speaking.
All right.
Yeah. So thanks very much, Miss Sonia.
Sorry.
Thanks to the previous speakers. I mean, I've been learning a lot from Ms. Beverly and Miss Pauline. So I would like to start with this. Primarily is the fact that sports it's a very, very niche aspect of law, to be honest. Sports and IP themselves are very, very niche aspects of law. So because they are very niche aspects of law, you more often than not need specialized, lawyers when you're dealing with it. But there is, there is something that is quite endemic in the practice of sports law today. The fact that a couple of people, I wouldn't say a lot because I don't know how many, but a couple of people copy and paste, terms of contract agreements, contractual agreements without sometimes paying cognizance or giving recognition to some of these nuances. And with sports, for example, it is very, very easy for you to be international in sports. I, for example, I live in Nigeria, but I've done a lot more work outside of Nigeria, but it wouldn't be that way if I was a conventional commercial lawyer or a criminal lawyer, for example, a property lawyer in Nigeria. So there is need to pay attention to some of the regulations in these multiple countries, but people rarely do that. And then I think that a couple of people do not, I'm beginning to see a lot more of late, but a couple of people do not pay attention to the governing law clause on the IP, itself. And then people often ignore the federation regulations, when drafting this contract, because if you're dealing with a Nigerian for example, that is signing, say, an image rights agreement with that is domiciled in Turkey, but is signing an image rights agreement with a company that is domiciled in Germany, you then have possibly, 3 jurisdictions, and you don't know which jurisdictions laws will govern the case. So I think those are 3 aspects that should be that should get a lot of attention. Those are some of the mistakes that I have seen so far working in the industry. But here is something that I think that people should pay cognizance to give attention to when they are drafting contracts. One thing that I know is that the law is a very, very precise concept. So you need to be as precise as possible when you're dealing with the law. So when you're defining IP, for example, you need to go as detailed as possible. Don't just say intellectual property, because there are various divisions of intellectual property, image rights, likeness, and all of the variants. For example, image rights is known as image rights in England. In mainstream Europe is known as personality rights. In the US, it is known as publicity rights. Even image rights itself is then divided into multiple divisions. There is image rights of a player, or say an entity. So I'm talking about a player now because I'm very used to the football aspect of these things. So of a player himself, if a player is representing a football club, there is that image rights, and then there is the image rights. There is collective image rights. When there is a couple of footballers, for example, representing an entity, say a federation or a football club. So that image rights actually belongs to the football club. So if you get what I'm trying to say, what I'm just trying to say is that I believe that people should be more exact and precise when they are, describing some of these things. You describe them and try to use as many derivatives of them, because if it isn't named, it should definitely be argued about when things get contentious. Then the second thing I would have liked to say is something that I said with the first point, the fact that the ownership of IP is really by one person. IP can be owned by multiple people. I would like to draw our attention to a very famous case. I don't know if we know it, but there was a case between Rihanna Fenty and Arcadia some time ago, where a clothing brand used Rihanna's image and produced multiple lines of clothing apparel with it. And then Rihanna sued them. And when adjudicating the case, the people, Arcadia now, the defendants in the matter, said that they had bought the image from the person that took the picture, who we know, of course, is the owner of the image. But Rihanna claimed that she owned the image used. And Rihanna is not a small person. She has a clothing line. She's very popular in the fashion industry. So our intellectual property, of course, needs to be protected. And the ruling was given, in our favor. The point I try to make with that particular incident is that there are multiple divisions of intellectual property, and I believe I would also advise that when things like that are concerned, you should try to cover every derivative of it. Then lastly, two things also is the fact that you should also try to, I think, put in the contract that there should be injunctive relief. Injunctive relief should be made available, because sometimes disputes take a long time to adjudicate. Sometimes arbitral panels could take 3-6 months. If it's litigation, you have gone a long time. We are dealing with arbitration here. 3-6 months, sometimes up to a year before an arbitral decision is given. But if you have to wait for such a decision to prevent an infringement or to stop the growth of an infringement that has already been made, a lot of damage would have been done. And then finally, I believe that Miss Pauline and Miss Beverly have said earlier, I believe that the actual arbitration, because Miss Pauline said that it is, the arbitration means is really party driven. So I believe that in it being party driven, you as a lawyer should try to ensure that you don't have the short end of the stick. I will give an example, but this is very, very sporting related. If, for example, you are signing an agreement with someone, I'm sporting related now, and you say that in the case of dispute, the Court of Arbitration for Sports in Switzerland should be the one that adjudicates the matter. Many people don't know this, but the Court of Arbitration for Sports in Switzerland takes a filing fee, an unrefundable filing fee of 1,000 Swiss francs. So if you are signing such a contract and you can't afford it, you have put yourself in trouble by agreeing to such a provision in the contract. So I believe that people should pay more attention to the rules of whatever court or arbitral panel that they are deciding to use in adjudicating matters. So that is what I have to say.
Thank you so much, Mr. Isaac. Thank you so much, Mr. Israel. That was really insightful. And one thing I hear you say, and then I take over with what you said so far, is that you must be precise, right? You never can go wrong when drafting. Define IP, define what it's about, define what it's going to cover. And also, if possibly, maybe even define this. You also mentioned several rights. Also, you also talk about image rights and the likes. So define this, be more specific in your contract. Thank you so much. So, Dr. Emmanuel, are you on this call? Please, can you confirm you can hear me? Because I would like to get your input on this.
Hello, good afternoon. I'm here. So sorry for coming in late. I was battling with network, but I'm here now.
Oh.
Yeah.
Okay, no problem. Okay, so Mr. Israel talked about it raised the issues relating to several rights. So I'm going to talk about different IP rights, right? So you just want to so basically you're going to just do like if you could just help us just do just a brief summary on the legal framework relating to just a brief legal framework and also so that we can properly aware that there are several rights because we have right, image rights, trademarks, and the likes, right? So we need to understand the legal foundation first, and then we talk about this right. And also like to know in respect of these different rights that are associated with sports, right? Which of these rights tends to generate the most common disputes, right? Using image rights, like Mr. Israel said, using image rights as an example, and how effective does Nigerian law protect athletes who operate at a high commercial level? So just talk about the right and then also the law, the Nigerian law that regulates this. Over to you, sir.
Thank you. Hello, I hope you can hear me.
Yes,
Hello?
yes, sir. We can hear you.
Yeah.
Yes, sir, we can hear you.
Okay. All right. You said which IP right caused the most disputes and perhaps the legal framework. So let's start first of all from the legal framework for protections of intellectual right and property and image right of players in Nigeria. There is no doubt about the fact that the law in respect of intellectual property in Nigeria is still scanty, but that is not to say that there are no here and there ways we can put things together, particularly as lawyer, in order to assert and defend the right of our client. But basically, the starting point would be the provision of Section 37 of the 1999 Constitution, which provide for the right of privacy and control over one personal privacy and personal information. And then you talk about the Trademark Act, which protects issues of names, logo, brand. And then you talk about the Copyright Act, which also protects right that are registered copyrighted, particularly from the for those who are registered with it. But there's no doubt about the fact that the enforcement, the compliance, the regulations is still very weak. And then going to the questions of which of these rights, I didn't hear your second question very clearly, but maybe you were saying which of these rights, please, can you just, so that I'm very sure of what I'm answering, please, can you just repeat it again?
Okay.
I'm battling with
Okay,
network.
I said, which of these rights tend to generate the most disputes? That's we have image rights, trademarks, we have broadcasting rights and the like. So which of these rights tend to generate most disputes? And using image right, like I said as an example, how effective does Nigerian law protect athletes who operate at a high commercial level?
Okay,
Is that clear enough?
Yes, it's clear. Well, I think the question of which of these rights generate a lot of issues and controversy, particularly for us in this part of the world, I think I will go for image right, broadcasting right, and issues of copyright. And the reason is because the enforcement mechanism is weak, and not only that, the awareness is not even there, particularly because, for instance, under the image right, issues of endorsement, sponsorship, betting, video games, when you bring up issues of right of people to their image, sometimes people wonder what exactly are you saying. that you mean I can't repeat this or I can't do this, and then they ask you if you understand. And then also why image right also is very controversial is because of the conflicting provisions between the federation, the club, and the player. For instance, the case of Salah, the Egyptian player, when so where there was a dispute between the use of his image by the Egyptian Football Federation and then his own club back in UK, and then the company that have the right to the management of his image. So image right really do comes up with so many issues, and particularly in this part of the world where enforcement mechanism is low, and so you see people violating and using this right in a way that go against constituting a passing off or an infringement, and then to even get it enforced becomes difficult because, like I said, the law is scanty here and there. But that is notwithstanding, at least the provision of Section 37 is a starting point, and which is good enough, is a constitutional provision which provide for right of privacy. And then, like I said, that alone could give a room for enforcement of actions, whether in passing off or whether in breach of contract, whether in breach of privacy, and whether in breach of trademark right. And in all this, it will bring certainly damages payment. But like I said, there are 4 issues or 5 issues that really is a problem. Number one, the fact that you find it very hard to determine, to build or to prove what is privacy, but that notwithstanding, once somebody acquired the status of a celebrity, right to image, to personality, to style, to uniqueness, to name, to brand become a lot easier. Then the weak enforcement mechanism, and then the jurisdictional issues. That is why sometimes you see some sport persons, particularly when they leave the continent of Africa, they assign their image right to a company. And it's not just because, or some people thought it's because of tax evasion, but no, it's not just because of tax evasion, because it becomes a lot easier for such corporate entity to bring actions to defend infringement of the right of privacy of the people that they have endorsement and sponsorship contract with. Thank you.
Yeah, thank you so much. Just a little clarification. So I know that you've mentioned the different issues. So you stated the image right. First of all, you said that the most the most common rights that usually bring these disputes are image rights and the procrastinating rights, and also image rights sits at the center of this dispute. So you've mentioned the challenges, or you've mentioned the issues. Do you think that there are solutions to these? Or what solution do you envisage? How can this be curbed? Just maybe just a minute. Can you just let us know that?
All right. Very, very well. I'm happy because when we look at the problem, it's also very good we look at the solution. So number one, again, as we've always been saying, and we are still canvassing, is the weak legal framework in Nigeria need to first be addressed. The weak legal framework in Nigeria first need to be addressed. And then number two is that I personally will advise outsourcing. It becomes a lot easier for image right of a player, of a celebrity, of a sport person to be coordinated, managed, and maximized, particularly if you want to get the commercial benefit of it. If it is outsourced to a corporate body, So without outsourcing, the corporate body settle the player or settle the celebrity, and then the corporate person will know how to go ahead to handle the interactions with the community. Then also too, number three that I would say is adequate clauses, remedial clauses in a contract. That is where we lawyers comes in when we are putting together a contract for a sport person. Those are areas we need to avert our mind to. And the number four is particularly with respect to the trade registry in commercial department in Abuja here to upgrade their services and realize the current trend globally, because some of the issues that are very peculiar to us here are not as difficult outside Nigeria. In other words, there are many jurisdictions that adequate provisions, even though where there are no express legislations on it, but they've used regulations to provide for so many of these things in order to ensure that they are not behind and that people's right and people's right, particularly the image right, are adequately protected. So those are the little things. And then we must fight ambushment. We must fight ambushment. The current trend of ambushment now in the sport industry, particularly with respect to issues of intellectual property, is becoming rampant, and we must find a way of working to stop it. Otherwise, it even goes beyond image right to broadcasting to sponsorship. In other words, the entire segment of commercializations of sport is attacked by the current practice of ambushment.
Wow, excellent, excellent. That's an excellent perspective. You talked about the weak legal framework that should be addressed. You talked about adequate clauses and all of that. Thank you so much for that clarification on that. Okay, so still on that. Okay, I'm going to take a pause on the old contract scenario and issue. Please, if you have a question, please do wait to post your questions on the chat box, and would also like to know where you're watching from. Please just do it to us to post that. So, Pauline, I want us to let's divert a bit, right? Pauline, if you can hear me, the issue we're talking about right now, who often frequently sits at the center of these contractual and commercial relationship in sports, right? It's usually the agents. I mean, so you worked across Europe, Africa, Middle East, you've worked with clubs and athletes, and you know that they often rely on agents. So, and also they're usually not lawyers, yet they disputes that are very sensitive in nature, relating to, like we said so far, relating to image rights, endorsement, and even termination contract, if we may say that. So to your own, from your perspective, does this expose the athletes to legal risk? Does it expose them to legal risk? I mean, when these disputes arise, and how can this risk better be managed? How can they better be managed? Yes. Pauline, please, can you talk on that? No, that's for Pauline.
Yes, please, I can hear you. Can
No,
you
for
hear
Pauline.
me?
Okay.
You can hear me?
Yes.
Okay,
Yes,
so
I
the
can
first
hear
thing
you.
is the answer to this is very affirmative. Yes. Agents just being the ones that review or represent players even clubs themselves is a very big risk, because most of these people don't have the expertise when it comes to intellectual property. And it does pose a big risk. And something that I should have mentioned while I was discussing your first question to me was that it's important that parties actually have legal experts or specialized lawyers. So you don't just pick up any lawyer, okay? You pick up a lawyer who has expertise in your area. For example, in this case, you'd have to pick up a lawyer who is experienced in sports and intellectual property to represent you, for example, if we're talking about the negotiations. But when we talk about the question at hand, of course, like I've already said, the answer is in the affirmative. There is a very big risk, and that's why I find most of intellectual property disputes, okay? Because most of these contracts, they'll tell you it's a standard contract, and the agents will be like, okay, I've read the contract, it's okay. After they've seen the money the player is being paid, the transfer fees and everything, and for him it is good to go. But most of the times, most of these agents, most of them are not even lawyers, okay? So you don't expect them to understand the precedent between, you don't expect them to understand the difference between owning a photograph and owning the image, or the subject of the photograph. So they wouldn't understand that of the two, who has more power or authority over for example, the photography if it is being shared. And that is why we see there's this very prominent case between a Ugandan academy and the Ugandan Federation. And these must have arisen because the Federation did not do due diligence or have the correct expertise to actually discuss the intellectual property rights in those contracts. Just to briefly tell you about this, is that there were 5 players who are playing with an academy, which is a club. It's a club, so the academy of the club. So the club definitely had the IP rights because they're in charge of the photographs that are taken and everything. So when the players were taken up to the national team, of course, the federation takes care of the national team. The federation said, okay, we are the ones in charge of every intellectual property rights in this case. The problem with that is that the federation did not have any contract signed with the players or with the club itself, so they could not even claim a single thing in that regard. And this problem literally arose because they did not have the expertise to advise them on this, and that is why they ended up losing a lot of money. But yes, it does bring about a lot of risks, and these are things that players themselves are not even aware about, and the agents themselves don't even advise them on that. For them, their only concern is how much am I getting, how much is the player getting, so okay, and that is it. They're just less concerned about sports and commercial issues. So you don't expect them to pay due diligence. So like I already said, it's important that parties get players, for example, get lawyers with expertise, especially in sports and IP. And of course, if they also know arbitration, so that it's very easy for them to negotiate such things, but also to negotiate things to do with intellectual property, because it doesn't make sense if you're going to say the club takes over your image rights, such as the case that I just discussed right now. So because the club, for example, only owns the intellectual property rights, that is to say, the photograph, they own the photograph, they don't own the subject. So that means they don't own the image rights. But in a circumstance where you land on a malicious club and you just have an agent representing you, then you're gone for good. You're not going to be able to earn from that. And the issue that is going to arise is that, for example, a player is going to get a sponsorship account, a sponsorship deal with a company, and they'll post on their Instagram pages or on social media. And then you will hear a club saying, oh, you know what? We are having issues. You're not supposed to be doing this. We own everything. We're the ones that are supposed to be earning. And yet, image rights are derived from the right to privacy, which everybody has, and that is in the Constitution. And in this very perspective, that is to say IP, there is no limitation to that right. So in a circumstance where you don't have legal advice, these kinds of things are going to be arising. That means the player cannot even sign their own endorsements, because the club owns everything, and yet they literally shouldn't. So it does really pose a very big risk. And in the African perspective, it's even bigger because the players are not that exposed to knowing the difference between the two of these, just to make their own personal judgments. But again, there is also an issue of not wanting to seek legal advice because they feel like they have an agent. The agent should be able to do everything, which is not the case, okay? So it does pose a big risk, and the best way to go around that is getting lawyers who actually have a specialty in these specific fields, because we've seen how people hire lawyers who don't have expertise in certain sectors of law, and then everything just becomes a blender and justice is perverted at the end of the day. So yeah, I hope I've answered your question.
Yes. Thank you so much, Valen. You did a great job there. I hear you. So beyond getting an agent, you need to also get a lawyer, not just any lawyer, but a lawyer experienced in the field. Thank you so much for the reminder on the risk that athletes faces in terms of that. So now, beyond just moving on, because you're a little bit so that we can be within time. So beyond the contractual disputes, many IP conflicts, right, usually happens in the market itself, in the marketplace itself. And one of the major issue that I see really happening as outside the commercial part of it is the issue of sports merchandising. It's a major problem across Africa, affecting kits and also branded equipment. So, Mr. Israel, please, I would like your perspective on this. What remedies are actually available to clubs, leagues, brand partners to curb these downstream infringements? And where do enforcement efforts most often break down in respect of this? So how can we curb these old infringements? I'd like to get your perspective on this. Mr.
All
Israel.
right.
Yeah.
Yeah, thank you very much for the question. And I would like to start with this. I'm a lawyer, quite all right, but I believe commercial question rather than a legal question. And I will start with this. So in 2018, Nike, a clothing brand, signed an agreement with the Nigerian Football Federation. The agreement was rumored to be between $3.6 to $4 million, right? So the terms of the agreement were that Nike would be clothing the Super Eagles of Nigeria for the 2018 World Cup, which they did quite all right. But I would like you to know that the jerseys were actually sold out in minutes. In fact, they were pre-sold. About 70 of them were pre-sold before they launched. And they were sold out in minutes. But the price point for each of those jerseys was about $90, right, at the time. I'm sorry, the price point for each of the jerseys, the lowest was $60 at the time. But the minimum wage in Nigeria at that time was 30,000 naira, which approximately was about $80. So that means that the jerseys were almost at par. They were costing as much as 66% of the minimum wage. So that means Nike made a jersey for Nigerians, but not for Nigerians, if you get what I mean. And because the jersey sold out in a couple of hours, and it was very much in demand, people started to make the fake versions of those jerseys, and of course, people started to buy them. As a matter of fact, I'm very, very sorry to name, but a company, AAA, made counterfeit versions of similar jerseys, and they were sold, I mean, from the original company, they were sold about $8 per one without the shipping cost. So with shipping cost, it was costing about $16 per one. So what I'm trying to say is that the first issue, I think, one of the things that cause this matter is the price point. It is the fact that many of these things are actually too expensive for the markets that the jersey manufacturers are trying to penetrate. On the first hand, please hold that thought. On the second hand, I have worked on a project like this. Last year, a German company wanted to come into Nigeria, and then they reached out to someone who in turn reached out to me. I was consulting for them. And when this question came up, what I did was that I spoke to the head. I spoke to someone who linked me to the head of one of the biggest markets where we know that some of these things are made in Nigeria. And I spoke to him. I told him that I would like them to be distributors. So when they are distributors, that have vested interest, they would make an attempt to ensure that counterfeiting is reduced. So that means that not just the companies, now not just Nike this time around, not just Adidas or not just Puma or whatever the name of the company is trying to enforce compliance. The guys that are doing it will also, be part of the enforcers. So those are the two angles that I like to approach this from. Then sorry. Then lastly, I would like to see that more often than not, I'm talking to Nigerians now, people around Nigeria, is that they should always try to, follow compliance procedures. If you follow compliance procedures, it is easy for you to claim for your rights. So when you have something that is not properly trademarked, not properly copyrighted, not properly, just your intellectual property is not properly registered with whatever enforcement or regulatory agency there is, it is a bit difficult for you to seek remedial measures, if you get what I mean. And then lastly, relating to this matter, what I would like to say, the advice I would give is that these guys should try to create tiered products, right? Mm-hmm. In my opinion, what makes a thing original sometimes is not quality. It is the fact that it has the stamp of the maker. So if there are some products, for example, that are more quality than Gucci or whatever luxury product you have, but cost way less. So it is not a matter of quality. The brand on it is what gives it originality. So I believe that the original makers should try to consider making good products quite all right, targeting this market with their brand on it. So that way, there are lower price points that people can afford instead of, because what makes Nigerians go for, or what makes Africans generally go for the fake of these things is that the original is not available for them. So if you make the original available at a price that they can afford, it then becomes easier for them to access it and easier for you to, maybe trace the fake ones if you come across them, if you get what I mean. So I hope I'm able to answer your question.
Oh, yes, you have. Thank you.
I wanted to come in after that, if that's okay, because a lot of I wanted to just say something very quickly. It's very important because the conversation has steered a lot around the sporting side. And just jumping off what Israel has said, very important thing he said about we need to be original. And when we're delivering services, whether as Nigerians or as Africans of a sporting nature, these services do not necessarily may have anything to do with a sport. For instance, I'm representing somebody now that is that has created a Pan-African school games. In fact, that is even the name of the product, Pan-African school games. So the whole purpose of today's session is to expand our minds about how our clients, how Africans can create products of a sporting nature, okay, that can deliver services to the masses. So beyond the scope of talking about football and players and all that, the scope of sports is huge. So we cannot limit the conversation to just talking about football. So I'm really glad Israel brought that segue in, okay, because we as Africans are limited in the types of products and a lot of people that would want to sporting services, products that have an original name, an original brand. So, case in point, I'll give an example. A primary school in Nigeria, school games. I don't know if any of games was set up by two Asian 5,000 children participate, converge. But guess what has happened? Experiencing and the whole embargo on getting visas, a lot of people can no longer travel out. They can't get visas easily to compete. Does that mean that our children are denied the opportunity to compete? No. It means that we now have to think about creating local games, local tournaments that our children can enjoy. right? And you'll be interested to know that a few of the local sports tournaments we have had very similar names. So, we had to advise our clients that, something, your game is going to grow leaps and bounds. This is the time to correct the name of your brand and get your brand name sorted so that in 2 years, that brand blows and there's no conflict between your brand and another brand. So it's just to say that the sporting nature of commercial activities is far bigger than just playing football and playing tennis. It also involves creating esports games. Esports is massive right now. There's a guy out there, I don't represent him, but his company is called Malio Games. Malio Games was connected to, I think it was to Disney, creating games that in collaboration with international entertainment production houses. So the scope of what we can do as Africans is massive in terms of sports and IP. But as we've all kind of alluded to, as we get bigger, as the appetite for African things becomes bigger, we too need to secure our own. So we need to take our branding seriously. Israel has alluded to that. We don't wait until something gets popular. You do the work, the foundational work at the beginning. You secure and protect whatever it is you've created before you release it to the general public. So I just wanted to put that out there because people miss out on other aspects of sporting activities that are equally as important to talk about, that also give rise to disputes. So I just wanted to put that out there.
Okay, that's fine. That's good. Evelyn, thank you so much for that input. So just staying with you a bit. I mean, we've mentioned several issues ranging from disputes and the like. So let's talk about enforceability. How are these awards usually enforced? How practical are the enforcement process, and where do enforcement challenges most commonly arise?
See, the
So
issue
let's
right now is people don't even take their commercial disputes to arbitral institutions. So I want us to really put this into the right frame, right? I don't want this to sound like a theoretical exercise. The reality is right now, commercial sporting disputes are not even being heard in the arbitral institutions that they need to be. At least I'm talking from from a Nigerian perspective. So we need to raise awareness. One, I would say practically, Prof has already alluded to the fact that rather than talking about challenges, let's also proffer solutions. I would say today, CIR, please put out some kind of white paper to encourage arbitral institutions in Nigeria to add sports dispute category. I've mentioned the ones in Lagos, the popular ones in Lagos, LCA, CIR, NICOB. We have multi-door courthouses that are now doing entertainment. There's no reason why they can't do this. We can easily get, with a lot of persuasion, private bees. Don't forget, there's construction. Construction is a massive act of sports. We need infrastructure to build a lot of the places where people will play, right? And we all know that construction disputes form one of the major categories of disputes globally, and Nigeria is no exception. But the problem is the disputes are not the sporting commercial disputes are not being heard in the right spaces. They end up going to national courts. So we need to build capacity within our arbitral bodies. So you see, I don't want us to talk out of context, talking about the interim award. People are not even taking these disputes in the first place. A lot of disputes of the commercial nature, sporting nature, they end up getting resolved privately. They settle because they don't even want to go into arbitration in the first place, or sometimes the clause is not even there. There's no ADR clause in the agreements. There are faulty, poorly drafted agreements. Israel has already spoken to that as well, because the law involved that put the arbitral bodies as the ADR, as the venues. So the arbitral bodies into the frame, how disputes, that's the first step. Because if we can't time, I remember 7 years ago, I took a proposal to Lagos Multi-Door Court to say, please, can we have sports as a category? I took that same proposal to the Lagos Court of Arbitration. I said, please, can we have sports as a category of disputes? If you do the research, majority of arbitral bodies in Nigeria do not have sports currently as a category, and that is a major issue, and that is also going to cause a problem with access to justice. So people they take recourse to other means. They go to national court. So a national court or a regular court, a high court, will be hearing a dispute of a somewhat sporting nature, but because it's under the umbrella of construction, they hear it anyway, whereas that dispute could have been heard in a specialist institution. So truly, I don't think we're quite there yet. If we truly want to talk strictly on sporting commercial disputes, we need to raise awareness that we should be taking these disputes to arbitral institutions that are ready to integrate commercial sporting disputes within their existing framework. If we don't do that, then we're not going to make headway. Entertainment has gone much further along than sports has. Entertainment is a category, IP is a category recognized by a lot of arbitration bodies in Nigeria. Why can we not have the same for sporting commercial disputes? Because otherwise we're just going to be having a very theoretical conversation, because not everybody is practicing in multiple jurisdictions. Do you know what I mean? So if we want to be practical, and if we want to really make progress as a country, as a nation, then that would be my recommendation. The CIR Port Harcourt, I know you're not, you don't necessarily hear disputes, but can you put out something after this session, after this WIPO day, to say, why don't we get arbitration bodies to incorporate commercial sporting disputes, so that we can even grow the expertise. Most of our council have more expertise when it comes to sporting disputes, not necessarily commercial sporting disputes. So that's what I wanted to say. I don't like to speak in an abstract manner. I like to speak as to what is actually really going on in the country. And that is what is going on in the country. We don't have a proper venue for commercial sporting disputes, and that should be changed.
Okay. Thank you, Bevelyn, for that. That was detailed.
I mean, I just had, this is the whole point, right? We are here to learn, but we're here to offer solutions, right? We're not going to come here and just talk for talking sake.
Exactly. Exactly. Okay, so I believe the chapter chair is on this call, so he has heard you clearly. We need to build capacity. We need to create the awareness, and we need to build capacity. Thank you. So moving on, just have a few minutes to go. I would like to ask Israel. So, Mr. Israel, this is going to be your last question right now on this issue. So I would like to get your perspective in terms of, so when this whole dispute arises and all of that, and I'm talking from an African perspective, not just limiting into Nigeria or limiting into football, how do claimants, how can damages be proved? How can we prove that in the industry? What's the quantum of proving this? Israel?
Okay, yeah, I'm sorry, the network broke for a minute. If I got you right, you asked how we can prove the quantum of damage to intellectual property. Yes, evidentially speaking.
Yeah, just in 2 minutes.
Okay, yeah.
Just in 2 minutes, because we're out of time.
All right then. Okay, so just in 2 minutes. To be honest, the quantum of damage is very, very difficult to prove. It is, yeah, it's very difficult to prove. That's why primarily, I say something to people, right, that there is law as a preventive mechanism, and then there is law as a reactive mechanism, as a corrective mechanism. You know, when someone has done you a wrong, you try to seek relief. But there is law as a means to prevent wrong being done to you. That was why when I was speaking earlier, I said something about guys being able to seek, parties to agreement, making sure that there are rooms for them being able to seek injunctive relief when a wrong has been done to them. So, for example, when your product has been wrongly, when there's a copyright, an infringement on your product, the first thing you should do is to seek an injunctive relief to ensure that that stops immediately. It is better to do that than to take them to court and be dragging, you know, who owns this, who owns that, until 18 months after, when the damage has been fully done. So I like to put that out first. So use law as a protective mechanism rather than as a reactive mechanism. Be proactive. Then on the second hand, one thing that I know about Africans generally is that Africans do not value professionalism. So this is a practical experience as well. I will keep the parties, names of the parties discreet. But there was this time when I was working on a particular matter. It was something related to this as well. And then, you know, the person, you know, hired a team of lawyers. We were like, I think 6 lawyers on the matter. And then what they were trying to prove was that an infringement had actually been done. So when it came, you know, time to bring the action to court, when it came time to, you know, say the extent of the damage that had been done, none of us had the skill to do it, because what we could do was prove that the damage had been done. And it was at that point that I realized that at the very beginning, the moment he hired lawyers, he should have hired accountants as well to you know, calculate the amount of damage that has been done, you know, to know the extent of the damage that had been done. So that way, you know, you can put financial metrics on it. So instead of, you know, because at the end of it now, the judge will rule in your favor, then how much do they award? If you get what I mean. And I would like to draw this to this case of Adrian versus Chelsea, a very long case, about 2008. So I have 2 minutes, but I will just try to be as brief as possible. So Adrian's contract with Chelsea was terminated. He had a contract with Chelsea Football Club, and Chelsea terminated his contract because he was found to have doped. I think he inhaled cocaine. His contract was terminated, and Chelsea was seeking relief, financial relief from him. So the amount of money that was said to be paid to Chelsea eventually was about 17 million euros. However, his contract was 2.3 million euros per year. So he had to pay even more than his contract. So what Chelsea did was that they calculated how much they lost because of that particular action of his, how much they could have made because of that particular action of his, and it was put together to determine how much he owed to them. So I don't think that was something that was done by lawyers. That was something that was done by accountants. So I feel that, generally speaking, we Africans should learn to value the services of professionals a lot more.
Can I say something to that point very quickly? What the entertainment industry does a lot better than we in the sports industry is they have valuers that value entertainment assets. And when we're talking about sporting assets, that doesn't even come into play. And I'm so glad Israel has mentioned this. There's a role to play for valuers. Valuers do work that we as counsel or dispute resolvers, etc., cannot do. Do you understand? And that ties in with IP. Every sound business owner, entrepreneur, club owner, academy owner, you name it, you must have an understanding of all your assets. You will take an inventory of assets. Every year, you will know what are the books saying. Your valuers, your accountants will do your books. So, you know, the conversation, maybe we just didn't get deep enough because there wasn't enough time. But when it comes to the damages, when it comes to injunctive relief, these things come into play. How does a judge, and this is why we need tribunals, which is why we need to try as much as possible to avoid taking disputes of a commercial sporting nature into the regular standard courts. We need to take these disputes into the arbitral institutions that work with people called experts. We use experts a lot in arbitration. They are needed because they do the quantification that counsel is not going to do. So it's important that we get that out there. IP has a value. and that value has to be assessed properly. Like Israel said, it's a metric, right? How do you know how much you're owed? How do you know how much damage you suffered if you can't quantify it? So I'm so glad Israel threw that one out there. So that's why I said it's not just football. It's about the financials, knowing the value of your assets. And just like any other industry, sporting assets are not just the human beings on the field, it's also the intangible assets that your business owns, such as your trademark, your logo, your patents, your designs, etc. So I'm happy that the conversation kind of expanded a bit, because sports has a breadth that many of us don't really appreciate. Thank you. Just wanted to get that out there.
Okay, thank you so much. So from what I hear us say, we need to, so beyond getting lawyers that are also knowledgeable in this area, we also need other professionals for expert evidence purposes. We need valuers, we need accountants, we just, not just lawyers alone, we need other experts in this field. Okay, so because of time, we'll just take just one more question because of time. Right now we are out of time. So Dr. Emmanuel, please, can you hear me? So looking ahead of all these, so we said a lot relating to quantum, relating to disputes and the likes. Looking ahead, there's also a question relating to regional framework. So now let's talk about the AFTA. So the AFTA protocol on intellectual property rights is intended to harmonize the IP framework across the internet. How realistic is this? Really, I mean, from a negotiating position of African stakeholders, licensing of IP across borders, within the next 5 to 10 years, what should practitioners be doing now? Yes, Dr. Emmanuel, please, can you come in here on this? Okay.
Hello?
Yes, sir. Yes, sir, we can hear you.
Okay. Hello?
We can hear you.
Hello?
We can hear you, Manuel.
I can't hear you.
Okay, we can hear you. Dr. Emmanuel.
Hello?
Yes, sir, we can hear you.
Okay, please. I lost you again for a minute. I guess you asked me a question.
Yes, I was asking you about after.
I
I
can't
was
hear
asking you
you.
about after. How realistic is after?
Oh, okay. Oh,
Yes.
all right. The whole
Terms of
idea of that is very salutary. Hello,
Can you hear me now?
Can you hear me? The whole idea of after is very salutary. There's this saying that when something is desirable but unattainable, you say utopia. That is not to say I'm being pessimistic, but I'm just like thinking about the whole concept of after with respect to sport and particularly sport intellectual property. Going forward, unless we are able to handle 3 or 4 challenges, I really do not see the impact of after, particularly in respect of the 54, 56 countries. Number one, the issue of enforcement mechanism that is centralized. As of today, we do not have a supranational court. There is no court of competent jurisdiction to sit over matter emanating from Ghana, Nigeria, Sierra Leone, whatever, and give a binding decision that can be enforced in any of the participating countries effectively. And that is number one. Then number two, since the main objective of AFTA is not even really about sport and intellectual property, I'm still thinking that it will take years for the attention of AFTA to shift to issues relating to other aspects, because for now, as we are all aware, the effort is still on trade, on commodity particularly. And that is not to say that the tangible commodities are not important, but just all about focus, or it's just all about taking it one by one. So in the interim, in the short term, I really do not see the impact of AFTA with respect to sport, intellectual property, and entertainment. But that is not to say that I cannot be proved wrong. And I would be too happy to be proved wrong, particularly if, like Bevlin and Israel said, if we are futuristic and we push the agenda not only from the after, but perhaps private organizations coming in to make proposals, to make contributions, and push the agenda rigorously.
Okay. Thank you, Dr.
I don't
Emmanuel.
even know whether you had all I said, because the network
Yes, I heard.
is so
Yes.
bad. And
Yes, I heard all you said.
all right, thank you.
Sorry, what you're trying to say is that the AFTA offers offers long-term promises with limited immediate impact, right? So, and then it's going to take time for that to come into manifestation. So we'll just wrap up right here. It has been a wonderful conversation so far, but I would like each of the speakers, maybe in just 30 seconds each, just a take-home point, something you want to say, just to clarify, just 30 seconds each. If you could change just one thing in the law, what would that be, and why? Maybe to improve the resolution of sports-related IP disputes, just in 30 seconds each. Dr. Emmanuel, since you were the last person that spoke, could we just hear from you?
I'm back again. You said?
Okay, I said just 30 seconds, just final takeaway. Just
where will be the point made by Beverly with respect to having an arbitral institutions for sport and sport dispute, and then to strengthen private-public partnership where the regulations of sport and the sport industry is not driven exclusively by the government, but as well having at the top level private organizations and private individuals. If we get those two things right, investment can come in, because nobody wants to put money in a place where you are not sure how dispute, if there is, because disputes are part of commercial venture, and if this dispute happen, how would they be resolved? What time would they be resolved? And if there are what, how would they be enforced? Nobody wants to put money in that kind of bleak, uncertain environment. So if we get right sport dispute resolution, and the number two, we push for regulation of the industry, not only from government, from private institutions. I believe our sport industry in this part of the world has everything it takes to compete globally. Thank you.
Thank you so much. Mr. Israel, in 30 seconds, please. Any final words?
All right, yeah, thank you very much. I believe we would have almost the same opinion, right? Because for me, regarding just sports commercial dispute and regulatory commercial disputes, one of the biggest problems that I have had is that at the lowest level there is very, very little access to justice. So, and like Dr. Olowunoni said earlier, if there is an IP dispute between a Nigerian and a Ghanaian, or a Nigerian and someone and an Ivorian, for example, there is no African courts that they can be taken to. AFTA does not cover for that. They most likely would have to go to WIPO or the International Commercial Chamber. That one is even, which are super, super expensive. So also, like Ms. Beverly has said earlier, it is important for us to have African solutions to African problems instead of copying and pasting from, from Europe and the rest of the world. So I believe that there should be more, local tribunals, arbitral tribunals, arbitral courts, and arbitral panels here, even up until state level. Because as about a month ago, I suggested it to the NFF. I wrote a paper on decentralizing the player status and arbitration committee of the NFF to the point that they are recognized institutions at state level, so that people don't have to wait till when these arbitration committees meet, so that they can meet every day, like the High Court, State High Court, Federal High Court, and every other court that there is, to make justice more accessible to people that are at top level and people that are at the lower level. Because if you are keeping it real, the top begins from the bottom. If there's no justice at the bottom, there will be no justice at the top as well. It's basically the same thing. And with more of that, like Dr. Olowoloni said in his closing, we can then get more investments into the industry, because without justice, not much can be done. When people know that there is no consequence for acts or omissions, wrong acts or wrong omissions, there will be no consequence.
Okay.
Thank you very much. Yeah.
Yes, that was really insightful. Ms. Pauline, any final words in 30 seconds?
Yes, please. I have some final words to say. And basically for me, what I want to say is, whereas we are looking at courts and everything, I think if we're looking at the sports perspective of it, is that one of the things that I would really love to change is to make sure that federations make it mandatory for sports stakeholders to have experts as their legal representatives. And this is basically to help us reduce on the number of conflicts that we're going to be facing, or disputes that are going to be arising, okay? Because most of these disputes are arising because a contract was not properly drafted, so the clauses were not explicit enough. And of course, even if they were, they note in the favor of the other party, so there is a bit of coerced consent. Besides that, the player doesn't know what they're signing. So for me, I would basically want, just like how players most of the times have agents, I think one of the things that I would want to change is to make sure that every stakeholder, especially players, have expertise. As I mean, people with expertise to represent them legally, so that all these things do not have to get out of hand. And should they get out of hand, it shouldn't be something that is originating from a contract. The dispute shouldn't come about because the contract was poorly drafted. At least if it can come up because there was a breach, it would be understandable. But to an extent, while we're talking about a contract that was poorly drafted, I really think that's the thing for me. I feel like if we do this, we'll minimize on a lot of commercial disputes, sports and commercial disputes, such as those relating to IP, because I mean, that's where most of them are arising, like the case that I gave, Proline vs. FIFA. It was basically because of that. This is a federation that didn't have expertise. So for me, I feel like that is one of the most important things before we look at all avenues of resolving this. And of course, everything else comes into place.
Yes, thank you so much. Thank you so much for focusing on the contracts to avoid the poorly drafted contract. Thank you so much. Then finally, Ms. Beverly, any final words in 30 seconds, please?
30 seconds. So let's get an update of the Trademark Act. It's very out of date. We need to update it. Let's cover the gaps. We don't currently cover things like image rights or personality rights in the current Copyright Act 2022. It would be great to have an amended version of that so that that area can be properly covered, so we don't have to resort to privacy as a way around enforcing protection of people's image. And I would also like to see a hybrid sporting, regulatory sporting and commercial sporting tribunal where we can fuse both competencies headed up by, people that are very competent. If we have just those three things, I think it would really move that needle quite far ahead. Thank you.
Okay. Wow. This was this was a robust conversation. I mean, I myself I learned so much from the speakers. Thank you so much. I'm wrapping up because we've really spent so much time. We have present with us the chairman of this Port Harcourt Branch, Port Harcourt Chapter. Say one or two things in respect of this conversation. Mr. Emeka.
Hello.
Yes.
Sonia, thank you so much. It's quite enlightening. I want to thank particularly the panelists. A lot of expositions. More or less, they were facilitating a training without realizing that. Beverly, maybe when you come to Port Harcourt for the conference, we have so much to talk about. Maybe that your proposal, we may have to look at it again, and you never can tell. I just want to sincerely thank you for finding time to take us through this. We are not taking what you have done this afternoon for granted. I also want to thank those behind the camera, my first vice, Mrs. Susa. I also want to thank especially Rita and her team. It's been such a very wonderful outing today, and the ESCO members of the Port Harcourt chapter. I wish that there's no end to this. Honestly, I'm enjoying it. And Sonia, I would have said, why did you stop? But anything that has a beginning must have an end. Thank you once again, and thank you everybody that has joined. This is what we are. Just sit back, wear your seatbelt, grab a popcorn and ice cream if you have. There are more to come. Thank you all, and God bless.
Thank you.
Thank you. Thank you so much. Thank you, everyone, for taking out the time and connecting. Thank you. Take care. See you. Bye.